Okay, on the record in the matters of the people of the state of Michigan versus Kathleen Bearden, Amy Fascinello, John Haggard, Marianne Henry, Michelle Lundgren, and Sean Maddock, council appearances.
Good morning, LaDonna Logan on behalf of the people.
Good morning, Kayla Crino on behalf of the people. Good morning, Your Honor. Mary Chartier on behalf of John Haggard, who's seated to my right.
Good morning, Your Honor. Kurt E. Kraus on behalf of Mr. Haggard, who's seated to my right.
Good morning, Your Honor. Nicholas Sundberg and Bethlehem Sean.
Morning, Your Honor. George Brown.
Twain Sullivan from the Office of Public Defender on behalf of Michelle Lundgren, who I see is appearing on screen by Zoom.
Okay, Ms. Lundgren, please nod if you can hear us. Thank you. Today is the date and the time that was set to continue the preliminary examination. Any preliminary matters before we call our next witness?
Just real quick for the record, George Danini on behalf of Kathleen Burden, who is in the courtroom.
Jared Koger on behalf of Kathy Burden, Your Honor. Good morning.
My apologies. Okay.
And good morning, Your Honor. Paul Stavlin appearing on behalf and with Amy Fascinello, who's seated behind me.
Very good. You have everyone now.
Yes.
That'd be great. We do the next 8. Okay. Any preliminary matters before we call our witnesses?
Your Honor, I have a small one. As the court knows, just had a very brief conversation about this in chambers. I myself and Mr. Koger, when this case was originally charged, represented the witness that the state intends to call first today, Mr. Jim Renner. Mr. Renner subsequently moved to new counsel. Matt Borgula as the primary counsel for Mr. Renner. As we were transitioning the file, we were contacted by Ms. Burden. We made all appropriate disclosures. We spoke to Mr. Borgula. We communicated with him. He talked to his client, and the long and the short of it is Mr. Renner consented to us representing Ms. Burden in this case, as well as Ms. Burden knowingly retained us, knowing of our prior representation of Mr. Renner. And I put all this on the record because what I want to let the court know is for this proceeding, I think the better course for me today is to not cross-examine Mr. Renner, and the co-defense counsel will handle the cross-examination.
Thank you for that disclosure. I think that's appropriate, and we did discuss that in chambers. Any other preliminary matters?
No, thank you.
Thank you. You can be seated and you can call your witness.
And at this time, the people will call Mr. James Renner.
You come right up here. Yes, and raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, I do.
Thank you. You can have a seat, Mr. Renner. Okay, can you state your first and last name and then spell both?
James Renner, R-E-N-N-E-R.
You can proceed, counsel.
Thank you. Good morning, sir.
Good morning.
In 2020, were you involved with the Michigan State Republican Party?
Yes, I was.
And as of 2020, how long were you involved with the Michigan Republican Party?
I retired at 11, so probably about 10 years.
And as part of your involvement with the Michigan Republican Party, what did you do?
Well, I was a precinct delegate for a couple terms, And then I was also, I attended the monthly meetings of the Clinton County Republicans and volunteered for various work assignments. And that could be, passing out signs, passing out literature going door to door, and other things of that sort. So I was basically the work for the party.
Now, prior to 2020, did you ever serve as a candidate for the electoral college?
No, I never did.
In December of 2020, were you called to a meeting regarding possibly being a member of a Republican electoral candidate?
No,
Did you go to a meeting at the Michigan Republican Party headquarters in Lansing in December in 2020?
I went to one on the 14th, but nothing prior to that.
Okay. Can you tell us how you were notified of the meeting on December 14th?
Okay. I was contacted by Janelle Leonard, and Janelle was the chairman of the Clinton County Republican Party. And to the best of my knowledge, our normal process for her to gather volunteers to do things would either be at the monthly meeting or sending an email to individual members soliciting their help.
Okay, and this, I don't mean to interrupt, but I have to ask questions.
Sure.
This time when Ms. Leonard contacted you, was it at a monthly meeting?
No, it was by email.
Okay, and do you recall when Ms. Leonard contacted you?
It was either the 12th or the 13th of December. The meeting was on the 14th, Monday the 14th. And I received very short notice. And so it was, I don't have record of that. And I know it was short notice because I normally keep a diary of my meetings, of who I'm going to meet. And it was not in any of my books concerning that. So it was definitely by the Saturday. It could have been on the Friday, which would have been once the so yeah, it was very short notice. But it was the meeting was the 14th, so Sunday was the 13th, Friday was the 12th. So either 12th or the 13th, but she contacted me.
And what information were you given about this meeting that was to take place on December 14th?
They needed someone to replace an elector that that had cancer.
And were you given a time and a location of where the meeting was going to occur?
Yes, it was. I would be at the Sekia Center, which is the Republican headquarters in Senior Street at 11:45.
And is that in the city of Lansing?
Correct, it is.
And did you have any question about, agreeing to participate in these meetings?
Not really. I had responded positively to other requests that she had made. I had attended a meeting in the past, I was in 2018, concerning a potential petition drive. I can't even remember what it was, but she wasn't available, so she asked if I would attend. And so it was not uncommon that I would just say, fine, I'm here to help. What can I help with? So no.
Now, in December of 2020, did you know how the electoral process worked?
No, I did not.
Did you actually go to the meeting?
On the 14th?
Yes.
Yes, I did.
And what time did you arrive?
About 11:45.
Okay, and could you tell us about how you got into the building?
Okay. About 11:45, I parked in the building's parking lot and then went to the entrance door and knocked on it. There was an individual there and I gave him my name and then he allowed me into it's a small lobby, into the lobby of the building.
Now, prior to December 14th, 2020, had you been to the Secular Center before?
Yes,
So this was not your first time.
it was not.
Okay. And while you were in the lobby, did you see anyone else in the building?
I think there were just a handful of people waiting back in that area, that maybe 3 or 4, something like that, small, very small number.
And what happens after you're admitted into the lobby, sir?
Well, we waited until eventually we were called down, and then we went to the basement.
Now, when you say we were called down, the first question I have is who called you down to the basement? If you know.
I don't have a recollection of individuals' names or their functions as far as that's concerned. It could have been one of the workers there, because I know there are 2 or 3 workers. I couldn't tell you who it was.
And when you said we were called down, could you tell us who was?
Yeah, it was the other people waiting.
Now, the other people that were waiting, did you know any of those people before December 14th?
No,
Did you meet them on that day?
Yes.
Do you remember who they were?
no.
Now, you said you were called down to the basement. Before December 14th, 2020, had you ever been to the basement of the Secular Center?
No, most of my activity was upstairs, because they would usually leave signs in one of the areas at the lobby or whatever to pick it up. The one meeting I attended was in the first floor, the conference room behind the lobby there. No, I had not been in the basement.
Are you able to describe the layout of the basement for us?
Yes, I'll try. There's one entrance, and you come into that entrance, and you look to your left, which would be north. And there were tables and chairs in that area. And so the room was, I'd say probably 1.5 times its size. Okay,
Of the courtroom that we're currently in?
that's correct. And the door would have been over here.
And
Okay,
for purposes of the record, you're pointing to your left.
that's correct. And the chairs were around the perimeter, which would be the north. And that would be this one, I think this way,
And for purposes of the record, you're
Yeah.
pointing behind you.
yes,
Now, were the chairs just in a straight line?
yes, pretty much.
And when you get to the basement, what do you do, sir?
Well, then we put our coats on the chairs and, excuse me, on the tables behind us, and we were instructed to sit down. Okay. Then after that, there was a introduction, a short introduction, because there were probably about 30 people who were taking the room. And I didn't know anybody. I'd never met anyone. And I think that was the case of some of the other electors. And so there was an introduction of the electors. Okay, like, this is Jim, and this is Dave, and this is whomever.
Do you know who, I guess, started the introductions or started the meeting, for, I guess, lack of a better phrase?
It was either Mayra Rodriguez, or it was Kathy. I won't say Burdette, but that's a name I used to have a poll with it, or Kathy Burdette. Kathy, it's the Kathy Burdette.
Now, did everyone introduce themselves, or were they introduced by someone else?
No, I think we introduced ourselves. You know, like, I'm Jim. And we went around with that, so. Now, again, because of the time frame, some of the stuff is, as far as who the actual individuals were, Mayra or Kathy, is a bit fuzzy. So I just wanted to caution you on that.
Now, when the introductions are going around, are you able to tell us if the meeting was only attended by electoral candidates, or were there other people at the meeting as well?
There were other people on the back wall, standing, that were not electoral candidates. Okay.
And before December 14th of 2020, did you know any of those people that were standing along the back wall?
No,
During the meeting on December 14th, did any of those people introduce themselves?
not to the best of my knowledge. One could have spoken, but I can't identify.
Now, after the introductions, what happens next, sir?
Well, after that, then the purpose of the meeting was discussed.
And what was the purpose?
The purpose was to develop an alternate slate of Republican candidates.
So it wasn't to recognize the electors?
No, not to my recollection.
And who in the meeting stated that the purpose of the meeting was to develop an alternate
Okay,
slate?
that's going to be fuzzy. I don't have that. It could have been Kathy, or it could have been Mayra.
Okay.
I'm not sure of that.
So are you saying it was either one of those two?
Yes.
Okay. Now, when the purpose of the party was announced, what happens next? I mean, sorry, purpose of the meeting.
Okay. And the purpose of the meeting was announced as far as its purpose. Okay. Then there was some general discussion, I believe, concerning what was going to happen. Okay. And that included, excuse me, the signing of a form. Okay. And but prior to that, there was a voice vote that was taken. There were two individuals that needed to be voted in as elected.
And who were those
There was
individuals?
myself and another individual whom I don't have his name,
And you were voted in as what?
as an elected, as a replacement for the two individuals that could not make the meeting.
And at the time that the voice vote occurred, did you know who you were replacing?
Yes, I did.
And do you remember who that was?
I was,
Permission to approach the witness? Yes. See if I can refresh your memory. I'm going to show you the last page of an admitted exhibit 14. Just look at this and let me know if that refreshes your memory as to who you were to replace.
yes, it did.
Okay, I'll take that back. And who was it that you were replacing?
Gerald Wall.
And you said there was a voice vote. Who voted to replace Mr. Wall with yourself?
It was either Kathy or Mayra.
And did the other electors either say aye or nay?
Yes,
And you said there was a second vote.
that's correct.
Do you remember who that second person was that was voted in?
I do not.
And on December 14th, 2020, did you have any idea of the significance of you being voted in as a replacement elector?
Not really, no.
Was that explained to you before the voice vote?
I think this is how you define significance. It was the idea that I would be eligible to sign for the slate of, I'd be part of the slate of electors that could sign. Yes, that was. But as far as anything further than that, no.
After the voice vote, what happens in the meeting?
Then after that, the process began. There had to be signing of a form. Okay. And that form was, I don't have the name of it. Okay. It was again, a form that had all the electors, and then you had to sign it in the, over where your name is. Okay. 16 electors, and each one there was a slot for their name, and you had to sign that.
And was the significance of the form explained before anyone signed?
It was my understanding, the significance of the one is that you were authorized as an elector. Number one. And number two is that there was a companionship that showed that Trump and Pence had won the election. That you agreed with that.
And when you say you agree with that, are you saying that the persons who signed agreed with that as electors or just as?
I can't speak for anyone else.
Okay, what was
I
your
did. I
understanding?
did, yes. That he agreed with that. I agree with it.
Where was this document? Was this document produced at the meeting?
Yes,
Where was it?
the best of my recollection on this, it was in the basement itself. Okay.
And was it just displayed by someone or was it placed somewhere?
It was on a table, okay? And since it already had been discussed, that's what the signature is for.
And did you sign that particular document?
Yes, I did.
Do you recall if the other electors signed that document?
I could not tell you. I did not witness anyone, so I did.
Did you recall any opposition to signing the document?
No. I didn't witness any.
Permission to proceed?
Yes.
And again, I'm going to show you People's Exhibit 14. I wish I had stapled it. I'm gonna ask you to look at the second page and then the third page. And then I'm gonna, when you're done, let me know.
Yes, the second page was a companion to the third page.
And were those the documents that were discussed in the December 14th meeting?
Yes,
Okay, and looking at that third page, do you see your signature, sir?
yes, I did.
And did you sign that page?
Yes, I would say that's the signature.
Thank you. Now, after that document is signed, did anything else happen at the meeting?
Well, after that was signed, but prior to that, I think there was some discussion concerning next, what we're going to do. All signed, okay. Then the talk was signed and we going to present it to the Senate. Okay, there's a time frame that had to be presented. Okay.
Now, just to keep everything clear, when they say they're going to present the document to the Senate, were they clear about whether this is state Senate or a US
Yes,
Senate?
it was a state Senate because
Okay.
the discussion then led to we were going to disperse and find a location, drive and find a location that was close to the annex, the capital annex, and wait for a call. And then we would then, once the call came, then we would walk to the annex,
Now, when you say we would walk, who's we?
the elected.
And so are you saying that the plan was that all of the electors were supposed to walk together?
They were invited. Okay, I think the intention was that they would all walk together. And that was my observation. Yeah.
Now, did you actually go and park somewhere and wait for further instructions?
Yes, I did.
And did you receive further instructions?
Yes, I had been parked for 5-10 minutes, and I received a call saying, change of plans, we're going to meet at the Radisson. Okay. And from there, we're going to, as a group, walk to the,
And did you relocate to the Radisson?
yes, I did.
Okay, and when you drive over to the Radisson, do you actually go inside of the hotel?
Yes, went to the lobby, and there were a number of people milling around, electors and other individuals. And there was an individual that, and again, I can't identify specifically who that was. It said, after we go to the annex, you're invited to come back for pizza and hot chocolate. And then after that, and we left and we followed, I think it was a female representative to the annex.
Now, when you were in the lobby of the Radisson, were you able to tell if all 16 Republican electors were present?
I could not.
As you're walking towards the annex, could you see if everyone was present?
I was walking in the front, okay, so I could not see people behind me. So I don't know actually if all were there or just some were there. I know there are a couple of individuals that had health infirmary, and my presumption is that they didn't make that long walk because it's cold and windy.
No one was forced to go, correct?
Not to my knowledge.
And you said you were walking towards the front.
Correct.
And did you actually go over to the annex?
Yes, I did.
And what happens when you make it to the annex?
Well, I was there by the door, and the state representative eventually requested that we be able to enter. And eventually they have obtained a lieutenant Green. Then the discussions were held with Lieutenant Green, who's probably the officer in command. And he said that no, there would be no entry, that the building had been closed, and that we could not come in.
And I'm not sure if we covered this, but did anyone explain what the purpose of going to the state capitol was?
Yeah, the purpose was to present the slate of candidates, because we were told that the representatives and senators had the ability to accept our slate of candidates versus the Democratic slate of candidates. But it had to be there by 2 o'clock.
And it's your testimony, you were denied admission, correct?
That's correct.
Was there any attempt to leave the envelope with the slate?
There was an individual that came in at a later time, male, that attempted to convince Lieutenant Green to accept the envelope and to take it to whatever authority there was that was overseeing the ceremony. And Lieutenant Green refused to accept that envelope.
So what happens after the group is denied admission and Lieutenant Green declines to take the envelope? What happens next?
Well, there's an individual, as I said, that was I think his name was Ian Norton.
Say that again.
Ian Norton.
Okay.
Okay. That began continued dialogue with Lieutenant Green. And then after that, I think he began to talk with media, but by then I was on my way out.
And when you say out, does this mean back to the Radisson for pizza and hot chocolate?
No, I had no desire to do that. I went back to my car, called my wife, said I was coming home, stopped, got a hot coffee at McDonald's, and went home.
Now, when you get home, do you do anything, or do you contact Janelle to let her know how the meeting went?
Yes, as is my normal custom, if someone asks me to attend a meeting, either for themselves or I write them a summary of what the meeting purpose was, what happened at the meeting. So they're versed in, as knowledgeable as possible of what is it. And that's, when I was in business, I did that, and I do it now. I did that at 4:30.
Now, as you walked over to the annex, did you see any TV or film crews there?
As we approached it, there was a film, I think he was on a tripod. Okay. The door would be here. We would be standing outside the door, and it would, I think the camera was over here something.
And for purposes of the record, you have indicated with your hands that the door would be directly in front of you.
Correct.
And the cameras were off to the right.
My right. But there could have been other people behind me, of which I was not aware of.
Permission to approach, Your Honor?
Yes.
I'm going to show you a still. This is People's Proposed Exhibit 17, but I want you to look at 17A, which is the first page.
That's me.
Oh, well, you answered my question before I asked it. So you do identify yourself in that photo.
That's right.
And is this as you are walking either towards the annex or away from the annex? If you recall.
It appears it's toward the end.
Now, previously, during an interview, do you recall being shown a video of the group walking towards the annex?
Yes,
And did you recognize yourself in that video?
yes.
Your Honor, people would move to admit People's Proposed Exhibit 16. It's a video that was previously shown to Mr. Renner. I don't know if there are any objections. I could put it up and for further authentication if councils want.
Any objection?
Just not sure which one it is.
Is everyone else unsure or anyone?
I am, yeah, so I'm coming on over.
We're practically family.
Is there an objection to People 16?
No objection, thank you.
No objection, Your Honor.
No objection, Your Honor, thank you.
No objection. No objection.
People 16 is admitted.
Renner. I'm gonna restart exhibit 16 and I'm gonna stop at about 4 seconds into the video. Do you see yourself in that portion of the video?
Yes, I do. I'm the individual behind the two ladies.
Yeah. Now, Mr. Renner, after the December 14th, 2020 meeting, and after you sent your summary email to Ms. Leonard, did you have any more tasks as an elector? Did you perform any more tasks as an elector?
No,
And as part of this case, you're testifying pursuant to an agreement for special consideration, is that correct?
correct.
And as part of that consideration, the case against you was dismissed, correct?
Correct.
You want a permission to approach?
Yes.
Sir, I'm going to show you what has been marked as People's Proposed Exhibit 9. It is a 4-page document. Do you want 5-page document? Do you recognize that, sir?
Yes, I do.
And is that the agreement that you signed that resulted in the dismissal of the charges against you?
Yes, I do.
People would move to admit People's Proposed Exhibit 9.
The objections.
I object, Your Honor. It's hearsay. Mr. Renner has already spoken about the fact that he's testifying pursuant to an agreement. As long, I assume, as he comes in and testifies, then the case against him remains dismissed.
Any other objections?
I join in that, Judge.
Well, it's not hearsay because one of the declarants is here and he's open, he's subject to cross.
It's out of court statement, Judge. Doesn't matter if it's here.
But the declarant has to be present. It's a hearsay is an out of court statement made by someone other than the declarant.
Correct, but you're not trying to amend his statement, you're trying to amend the document, and they're saying the document is hearsay, which I agree.
Well, by signing it, he adopts the language which makes him a declarant.
I understand, but he stated on the record that he's entered this agreement. I don't even know why we even need it as an exhibit.
Well, Your Honor, I understand that the defendants are objecting. The crux of the matter is this document outlines the terms and conditions, which I anticipate that would be a subject of cross. And I think the best evidence for the court to see what the terms and conditions are is the document itself.
Okay, I think then if they open the door for that, that probably makes sense. But this document, obviously, and the objection was that it was hearsay. I can't see how that could be offered for the truth of the matter asserted, because it's an exhibit about,
But it's not hearsay.
well,
Because
the objection is hearsay. So
I get
even
it.
if it was, it's not, even if it's arguably hearsay, if it's not offered for the truth of the matter asserted, it comes in. And this is not offered for the truth of the matter asserted. It's about why his case was dismissed.
I think it is offered for the truth of the matter asserted. The government is trying to get it in to talk about the terms of his agreement with the government. I mean, they've already articulated, he's testifying here, his case was dismissed.
As
If they
part
want to
of-
ask
of
further
pursuant to
questions.
this agreement, and her anticipation is that you all are gonna ask some questions. So how about this? I'm gonna grant the motion. I'm gonna grant the objection, sustain it, and then if they open the door, it comes in.
Okay. Just a few more questions, Mr. Renner. Back at the meeting at the Michigan Republican headquarters. When the discussion turned to presenting the document to the state capitol, did you hear anyone objecting to that plan?
I did not.
People will pass it, Shara.
Thank you, Your Honor. Mr. Renner, my name is Mary Chartier. Because of the courtroom size, you have to swing to your right for questions from me. So I want to try to do this chronologically as best as I can and take you back to the message that you received from Janelle Leonard, you said?
Yeah.
Which is the request for you to participate as an elector.
That's right.
Did she call you, or how did that communication occur?
The normal process is to send me an email, okay? And because I don't really respond that quickly on the phone, what I do on email, she could have called, okay, which would be outside of the norm. So when I got involved in this, I went back to determine if I had the old email. I did not. But as I said, it was the normal process that we had used, that an email request would be sent, and then I would use time for that.
So I just want to be clear, Janelle Leonard is the only person who contacted you to participate in this meeting?
That's correct.
And she's someone who you knew before?
Oh, yeah.
And she's someone who you trusted?
Yes, I did.
The purpose of the meeting was, what did you think the purpose of the meeting was?
I really didn't know what the purpose of the meeting was, other than to fill in for an elector who could not make it. Okay. My presumption is the individual had COVID. So to the extent that beyond that, I was to attend the meeting, fill in for that individual. No explanations beyond that were provided.
So you weren't told at that time, for example, you'd be signing any documents?
That's correct, I was not.
You were not. And were you told who was planning the meeting at all?
No, I was not.
Were you told, for example, how it was being planned by a committee, by a group of people, anything like that?
No.
When you went there, how many people in terms of electors were present? Do you recall?
I think I was one of the last to arrive. So that would have made 15, 14, something of that sort.
Now, you had indicated earlier you weren't told how the electoral process worked. So Ms. Leonard didn't share that with you, correct?
That's right.
When you got to the meeting, did anyone tell you how the electoral process worked?
No.
Did you hear anyone announce it in the meeting? And for example, maybe you were, distracted or anything like that?
To the best of my memory, well, again, let's get specific when you're talking about the electoral process. Okay. Since that time, I've learned a little bit more about it.
Great. And I'm going to stop you just there for a minute and let you finish your response, but I'm not interested in what you learned subsequent to the meeting. So for example, if we can imagine from the time that you were at the Michigan Senate or at the Capitol, anything you learned afterwards about how the electoral process works, I'm not asking you.
Yes.
I'm asking you essentially leading up to that meeting. So from the time Janelle Leonard contacts you to the time you're signing that document, do you recall anyone at the meeting, for example, standing up and saying, let me explain to you how the electoral process
Not
works?
that I recall.
When you went, you said that you were milling about and then went down into the basement. Do you recall, were people like chit-chatting with each other, or was it silent?
I think there was some informal discussion, but not much.
And then ultimately you said that there was an introduction of people. So people were saying, I'm Jim, I'm Larry, I'm Sally, that sort of thing, correct?
That's correct.
And your recollection is that Ms. Rodriguez and Ms. Burden kind of led that in terms of, hi, I'm Kathy, hi, I'm Myra.
That's my recollection.
Okay. And so essentially led introducing people to one another or encouraging people, for example, to just say their name?
Yes, that's my recollection.
And you don't know why they did that though, do you?
Well, as I found out, they were,
So
my understanding
I'm going to
is,
stop you for a minute. When you found out when?
well, when I looked at the form that authorized me as an elected for the replacement of Gerald Wall, there I identified that they were the chairman and secretary respectively of the Michigan Electoral Commission. And prior to that, I noticed that they had involvement. Okay, so that's why I identified that they were kind of the leaders, kind of the.
So let me ask you this. What do you mean by involvement?
I think if recollection serves me, they're the ones that did the voice vote for the candidate, for myself and the other individual, or led it, or started it, or whatever. And I think they also, in that, were involved in discussing kind of what the objective of the meeting.
Okay, so they asked for a voice vote for the two alternate electors, you and another gentleman,
That's
correct? And then they talked about what the purpose of the meeting was, just informally.
Define informally.
So for example, was this I don't know, do you know Robert's Rules of
Oh, yeah.
Order?
Yes,
Okay,
I do.
right. Was it a meeting like that
No.
where, okay.
No, so in that respect, it would be more informal.
Do you know who Sean Flynn is? He's a lawyer for the Trump campaign.
Yes, I believe I do.
Did you recall seeing him at the meeting?
I think I do recall seeing him.
In the basement I'm talking about.
That's right.
Do you remember Mr. Flynn being the one who actually gavelled the meeting together?
I do not remember that.
You didn't see Mrs. Burton do that, correct? She didn't gavel a meeting, right?
I don't remember any gavel of the meeting together.
So what you remember is sort of people informally talking about the purpose of the meeting.
That's right.
And the meeting, to your understanding, and I don't want to put words in your mouth, so if I'm summarizing this incorrectly, please let me know. Your understanding was you were signing a document, you and the other Republican electors, so that to indicate that you supported and you cast your vote for then President Trump, correct?
That was part of the development of the slate of candidates, okay, that the electors signed. That slate would then be presented to the Senate along with, that would be considered along with the Democratic slate of candidates. So that was my understanding that that would take place, okay. And that was one of the purposes of the meeting. The other purpose is that if there was successful recount that ended up in showing that President Trump actually won, we would not have to reconvene again because the signatures were already there.
So I want to make sure I understand this. So dual purpose, the first purpose in your mind was we're Republican electors, we're casting our vote for the Republican candidate for president, again, then President Trump.
And
Is
Vice
that
President,
and Vice President Pence, is that accurate?
That's correct.
And that didn't come as a surprise to you that Republican electors are casting their vote for then President Trump.
No,
It would come as a surprise if it was the opposite, right?
That's-
Casting for Joseph Biden.
that's it.
And then the second is, and I, again, want to make sure it's accurate in your mind, a contingency. So if President Trump, then President Trump, is deemed to have won the state of Michigan, Republican electors have cast their vote for him. Is that accurate?
That was my two takeaways from the meeting. Correct.
And at the time you said if there had been a recount, were you aware of pending litigation going on to challenge the election?
There was so much going on at the time. I didn't know if it was pending, hoped for, or had been turned down. It was, I think, the idea behind that there would be, hopefully, if there was a successful, then that we would not have to get involved.
Was there talk at the meeting at all about any of this litigation, whether it was informally or, one-on-one, for example,
Oh,
or
yeah.
as a group?
Yeah, there was informal discussion.
And when I'm talking about informal discussion, I'm talking about sort of one-on-one.
Yeah.
How long would you say in that, well, how long was the meeting to the best of your recollection?
The best it was between an hour and 15 minutes.
Were there times where someone was speaking and then everyone was silent?
There could have been, but there was a lot of talk, a lot of side talk going on. Because everybody was energized, thinking that if this was successful, President Trump would be deemed the majority vote for the state of Michigan. So there's a lot of energy going toward that direction. So there was discussion according to that.
And so lots of discussions, and I want to make sure, so for example, you're talking with one or two people, other people are talking, that
Yes,
sort of thing.
yes.
Now, you weren't, when you said that Mrs. Burden and Mrs. Rodriguez, their names were listed on a form, you don't know how they were deemed to have been the sort of de facto chairperson and secretary, correct?
No, I did not.
Okay, and for all you know, it could have been random, somebody picking a couple of names out of a hat, right?
I would hope not. I would hope that they had the expertise and the authority to fulfill those positions.
But you don't know that, correct?
That's correct.
The people who were standing in the room besides the electors, you said there were people standing on the back wall.
Yes.
Do you remember who any of those people were?
No.
Did you know if there were people from the Trump campaign in the basement?
I think there was discussion. The assumption was, but since I didn't know anyone, and there wasn't, to my knowledge, to my recollection, a formal announcement of who these individuals were, it was just left to interpretation.
Do you know if any of them were lawyers?
I couldn't tell you.
You said you knew who Sean Flynn was, or you learned who Sean Flynn was?
That's correct.
You don't recall him gaveling the meeting to start. Do you recall him speaking at the meeting?
He could have spoken at the meeting, but I do not remember a gathering starting the meeting. Okay, maybe I was talking with somebody, I don't know, but I don't remember that. That would be a much more formal process than I remember.
It sounded like this was, you get a lot of people in the room, everybody's talking. I mean, it just.
Well, there was more structure than that.
Okay.
It was not, you mentioned Robert's Rules of Order. I don't remember that being followed.
Okay. Now, the form that you indicated that you signed, this signature page here,
Yes.
is that accurate? And then you said that there was another sheet of paper that indicated
Yeah,
that
that's the companion.
the companion. How were those two sheets of paper placed on a table? Do you remember?
I've been asked that time and time again, and I have thought long and hard. I cannot remember.
Do you, so you don't know if, for example, if they were back to back or two separate sheets, you don't remember?
I no, I could not remember.
Did you read, so you know there are two aspects of the form, the signature page and then what we'll call the cover sheet. Did you read the cover sheet and the signature page?
The one that you're showing to me now?
Yes.
I didn't read it word for word, but if you look at it, you get the gist of it.
Sure.
Yes, to that point, I did. I said that.
So you knew the gist of it, but as you indicated, I just want to make sure you didn't read word for word what it said.
That's right.
You also probably didn't see if anyone else was reading it.
No.
Or even glancing at it,
I
correct?
cannot tell you that.
Now, you indicated that, and I guess I just want to be clear, you're testifying here pursuant to a special consideration agreement. And again, that's essentially your case has been dismissed, correct?
That's what I understand. Yes.
Okay, and you're cooperating in exchange for that with the Attorney General's
That's
office.
correct.
But you're not saying anything that's factually inaccurate, correct?
Not to my knowledge.
Right. Not, so you wouldn't do that to get your case dismissed, correct?
I'm here to tell you the truth as I remember it. If I cannot remember something, I will not say it. Okay. Now, keeping in mind that this is 39, 38 months ago.
Okay.
memories get hazy.
Sure.
So to that extent, that could be an issue. But beyond that, no. I'm telling you the truth as I remember it.
And you were charged with 8 felony counts. Is that accurate initially?
Correct.
Were you surprised when you were charged with felonies for intent to defraud?
Absolutely.
So let me ask you this, and I'm going to go through a number of these with you. So I'm going to ask you essentially in the time period between when you were contacted by Janelle Leonard,
Yeah.
and then when you signed those documents and left the building, walked to the Senate. So that's that roughly that time period, when you first are contacted and then when you leave the Michigan Senate. And if you need me to break it down because your intent changed along that time frame, please let me know. But during that time frame, when you agreed to be an elector, when you signed that document, when you walked to the Michigan Senate, during that meeting in the basement.
Excuse me.
Oh, sure.
We didn't walk to the Michigan Senate. We
Okay.
never got in. We went to the Capitol Annex and attempted to get in, but we never got in.
Thank you. And thank you for that clarification. So from the time you were contacted by Ms. Leonard to the time you agreed to go to the meeting, sign the document, walk to the Capitol Annex but didn't go in. And again, if your intent changes along the way, let me know. At any point, did you intend to falsely make a public record?
No,
At any point, did you intend to alter a public record?
no,
At any point, did you intend to forge a public record?
no,
At any point, did you intend to counterfeit a public record?
no,
At any point, did you have the intent to defraud anyone?
no,
At any point, did you have the intent to injure anyone?
no.
You were charged with conspiracy. So among the other electors, are you aware if any of the other electors intended to falsely make a public record?
I did not speak to anyone specifically concerning those issues.
Okay,
All I can tell you is the individuals that I witnessed during that time were all conscientious individuals that were attempting to do the right thing as far as they knew what was the right thing. And did I pick up on any discussion about that this could be an illegal activity or we could be subject to charges against us? No. The reverse was, we were told by, and again, pardon me, but we were told that this was an appropriate process. Okay. So to specifically address your question, I would say no.
and you believed, I mean, again, I want to put words in your mouth, so correct me if I'm wrong. You believed it was an appropriate process at the time, from the
Yeah.
time you were contacted by Ms. Leonard to the time you left that Capitol Annex.
I believe because I was believing what we were being told by the individuals at the meeting. The individuals that were representing themselves as appropriate leaders. Yes, I was.
And you were charged with other counts too, or you were, excuse me. And I talked about a public record, but I do want to ask you this specifically about a written document, because you did affix your signature to that signature page. At any point in time, again, from the time you were contacted by Ms. Leonard to the time you left the Capitol Annex, was it your intent to publish as true a false document?
No,
At any point, was it your intent to publish as true a forged document?
no,
At any point, was it your intent to publish an altered document?
no,
Publish as true an altered document,
No.
excuse me. And at any point, was it your intent to publish as true a counterfeit document?
no,
Was it your intent, again, from the time you were contacted by Ms. Leonard to the time you left the Capitol Annex, to ever knowingly file a false document?
well, no. And I hesitate because the definition of file, did that mean including providing the slate of candidates to the Senate? I mean, because that was the objective of the exercise.
So let me ask you this, though. The objective of going to the Capitol Annex was to try to file that document. At that time, did you believe it to be a false document?
No, did not.
And again, from the time as Leonard contacted you to the time you left the Capitol Annex, did you intend to publish a false document?
No,
Or did you intend to make a false document?
no,
And correct me if I'm wrong, it seems just based on your body language and the things you said, this is like totally contrary to what your intent was that at that time period.
absolutely it was.
That you, if you had thought, and again, correct me if I'm wrong, if you had thought that a crime was being committed in terms of signing your name to that document, it sounds like you never would have agreed to go to that meeting. Is that accurate?
That is accurate, absolutely.
And it sounds like if you had learned that at the meeting or had even suspected it, you would have left that meeting,
I
right?
would have, yes.
And again, just based on I'm just kind of reading your body language and the things you say, if you had thought that people were talking about an illegal process, would you have spoken up at the meeting and said, stop this?
I would have challenged it because my background is enforcing the law, not breaking the law. I brought my family up that way and we respect the law. So to the extent that if I knowingly had been told that, first of all, that this was a questionable process, I would have raised my hand and said, no, let's discuss that a little bit more. The actual opposite occurred.
So, right, so I'm using the term illegal, but you actually said even if you thought it was questionable, you wouldn't have participated, or at least you would have challenged
I
it.
would have challenged it.
And when you said your background is, you said in law enforcement, you said, or just upholding and following the law?
Both,
Okay, may I ask what's your background in law enforcement?
7 years in state police,
Okay, Michigan State Police?
Yeah.
May I ask what years those were?
70 to late 76.
Did you have a career in law enforcement other than those 7 years?
No.
And I think you have to swear an oath when you become a police officer, correct?
Yes, you do.
And you have to essentially swear to uphold the law, correct?
Correct.
Even when you were no longer a police officer, it sounds like you took that oath that you took extremely seriously
It's the foundation of this country.
and impressed upon your children that same oath.
Absolutely.
And you said that foundation of this country in following the law, that's what you believe, correct?
Yes.
And that's how you tried to live your life, right?
That's correct.
Including on December 14th, 2020, right?
That's correct.
And again, as former law enforcement, if you had believed a crime was being committed, you would have stepped in.
Absolutely.
One moment, please, Your Honor. Okay. I have nothing else. Thank you, sir.
Thank you, Your Honor. Nicholas Summer, gonna finish on that. Mr. Renner. You mentioned how long ago this all occurred and your memory's a little hazy.
That's correct.
I just wanted to ask, do you have any memory issues in general?
No,
And you take any medications that could affect your memory?
no,
Now, you're a retired state trooper. And
actually, I never retired from the state. I left that position prior to that. And I was not a trooper. I was one of the security officers. I was in the first school of Michigan State Police security officers. Whose primary function was patrolling the Capitol complex and other governmental property. I served in that role for 2 years, and then I was assigned with the government's detail for 5 years.
you're actually involved with the security at the Capitol.
Yes,
So when you in the group walked to the Capitol, you didn't feel like you were doing anything wrong?
absolutely. I actually walked to the Capitol Annex.
Right.
Absolutely not. No.
You're a retired businessman?
Yeah.
What kind of business did you?
I was a HR executive for a global company.
When did you become involved with Republican politics?
I'd say probably, probably 11 to 12 years ago.
Is it fair to say your involvement was out of a sense of duty?
Yes,
And on December 14th, 2020, you're called, you agreed to participate as a sense of duty and not as a part of a desire to defraud or commit any crime.
no, it's a sense of duty.
Given the sudden nature of your involvement, did you seek any legal advice prior to your involvement?
No, and here's the issue, because I was contacted on short notice. I'm very active in my church. On Sunday, we're there from 9:30 to there. Okay. I really didn't have an opportunity to do any research. And also in the previous request made by Janelle, were pretty innocent. Okay, so I didn't have any concern as to this could develop into something which is developed into.
Is it would be fair to say you were led to believe that your actions on December 14th, 2020 were part of a legitimate political strategy and not an attempt to undermine the election?
That's correct. Let me clarify, when you say political strategy, I thought it was a process that was legitimized. We were told that it was appropriate, that could be used to develop a second slate of candidates. So in that respect, was it political? Yes, but was it political in other terms? No, that's the terms in which I understand.
Was it your understanding this was based on historical precedents as well?
We had heard that. Okay, there's a discussion about this had been done in the past, but as far as specifics, if they were discussed, I didn't hear them. Okay.
And you believe that your actions were your actions were taken under the belief that they were contingent upon the success of the ongoing investigations, litigations, or potential fraud in Michigan?
Well, actually, there's two parts to this process. The first one is the actual slate of candidates of the electorate. Would that be accepted by the Senate? And would it be acted on by the Senate? That was the first step. The second step was, in the event that there was a successful recount, we had already voted in support of Trump and Vice President Pence, and therefore we would not meet again. So it was a two-parter.
What was it your belief or understanding at the time that had you not signed this document and Trump was found to have won Michigan, that he basically would not have gotten those electoral votes?
That's a new one. I don't think it came up. I don't think it was, to the best of my recollection, I cannot remember it being discussed at that time. So that's a new one.
You understood my question?
Yes, I did.
And is it correct to say that your decision to cooperate with the Attorney General's office to have these charges dropped was motivated by a realization of a misunderstanding of the process rather than acknowledgement of criminal intent?
Correct. Let me correct that again. Okay. I think it's a twofold. It was not understanding the process and not being informed of what the process was. Being told during the meeting that this was an okay process, that it was. The second part is the charges. I just couldn't see myself being in that meeting, doing that. Okay, so it was a two-parter. That one too.
So how old are you, sir?
Pardon?
How old are you, sir?
77.
So it's a part where you misunderstanding of the process and the potential to spend 14 years in prison at 77 years old. Is that correct?
Well, no knowledge of the process, not misunderstanding the process, but no knowledge of the process. Okay, and the process, I would define the process we're talking about. If the process is the electoral college process, I had no knowledge of that. If the process was the process used on the 14th, yes, I had knowledge of that. We were told that that was a legitimate process.
Okay, we need to go off the record. That mic has come undone. She's gonna come check it. Can you like tap it? Let me see. Okay, there we go. Can we just make sure nothing's on that? Okay, back on the record.
When you're in the basement signing this document, and you sign this document, it's the general understanding of the room. Nobody was there to defraud anybody.
Absolutely not. To my understanding, I didn't talk with all 16, okay? And I really didn't talk, I had one discussion, a short discussion with one individual, and that was free discussion. But as for me to represent the thoughts of the other 15, I can't do that. But did I see or hear anything that would lead me to that thought? I did not. Okay.
So you certainly made no agreement to commit any crime.
Absolutely.
Thank you.
Morning, Mr. Runner. My name is George Brown. I represent Marion.
Okay,
I'm going to ask a question that you've already kind of covered. I just want to clarify.
yes,
So it was your understanding that those votes that you were casting that day would only be counted, it would only be cast if Donald Trump was declared the legal winner of the election in Michigan, correct?
can I think on that one because that's going back. I would say that is probably not correct. And the reason is that because we're going to present that immediately to the Senate, they would have to make a decision at that point in time. So I don't think the time frame that we were talking about would have allowed that clarification that Trump was the actual winner, because that would be sometime in advance. Okay. So do you understand?
I think I understand your answer. Let me clarify the question.
Okay,
When I say to be legally counted, I mean to be legally counted as part of the electoral college in the final calculation. Your intention was only for your vote to be used if Trump was determined to have legally won the election.
correct.
Thank you. No further questions.
I don't have a lot of questions that have been asked, but
Could you speak up just a little bit?
I don't have a lot of questions because they've been asked, but I want to be clear. When you were originally called to attend the meeting, were you told at that time that this was going to be a contingent document?
No,
Okay, so you didn't get a lot of details, did you?
none.
So the details that you did receive as to the purpose of the meeting were received at that meeting, correct?
That's correct.
And they were received in the basement, is that correct?
Correct.
And they were received in the basement where all the other 15 electors were present, correct?
That's correct.
And you're not sure who disseminated that information,
That's correct.
but you're very certain it was disseminated.
That information was, that's how I gained that information. Yeah.
So that information then would have been available to all 16, correct?
Well, it should have been, because they're all there.
The document that was signed?
Yeah.
Okay. In question by Ms. Chartier, you indicated you couldn't recall if the documents, the signature page and the remainder of the document were together.
That's correct.
All right. Or it's possible that they were separated?
It's possible,
Okay.
but I saw them both. Okay, and so they're just, to my recollection, they're just two documents. There's a signature signed, and then there was, I don't know what the true name of that second document was, but showed that Trump intends to win.
Were they stapled together?
I don't
Is it
remember.
possible they were apart?
Is it possible?
Yes,
Yes,
because you can't recall that.
that's correct.
Did you hear anyone in the meeting make statements contrary to your understanding that this was a contingent document?
Contingent.
Yeah,
Based
I'm gonna
on what?
object, that assumes facts, not evidence.
Can you repeat your question?
Well, you've
I want
described,
you to, no, you're repeating a question for me.
oh, did you hear anyone in the meeting indicate an understanding other than yours that this document was contingent on whether by later proceedings, Trump would be declared the winner?
You're
That's a
not to answer
different
this because this is an objection. That is a different question than what you asked before. So are you withdrawing the previous question?
I'll withdraw the question.
Okay.
You didn't receive any information at that meeting that the document was going to be a legitimate document certifying that Trump had won the election, did you?
Say that again, because I'm not sure I understood.
You weren't told that this was going to be the document certifying that Trump had at that time on December 14th won the election, correct?
Well, that would run counter to their attempt to present it to the Senate on that same day at 2 o'clock. So the other gentleman, I think I addressed basically the same question, is no, it's my understanding that the presentation, as we signed it, would be presented the same day, and then meaning that the votes were, that we had agreed he had won, and it then would be up to the Senate to make a decision as to which one they would select. So in that instance, I would say the first question was not correct, because it was not contingent. The second objective, in the event that there was a recount, that was contingent, where we signed. That was contingent based upon a successful recount. The first one about the vote, whatever that form is called, was not contingent to my understanding.
I think I understand. So the first document was to declare that you were the electors, but you understood that it would only take effect, okay, if a recount had produced Donald Trump as the winner.
Okay,
No, no,
I'm
no,
really
let me stop
confused by
him.
the
That's not
document.
what he just said. My understanding of what he just said was that there was two reasons. This one document, not two documents, was used. One, that they were gonna send it off to the Senate that day, and the Senate would make a determination as to which one they were gonna use. And then that same document would be used contingently if there was a recall. So it's one document, two purposes that you believe it was being signed, is what my understanding
Her
is.
Honor has indicated that, has stated that probably better than me. Do you subscribe to the statement that Her Honor just recited?
Yes.
Thank you. Thank you, Your Honor.
Thank you. Okay.
Oh, there's one.
I know you can't see me, Judge, but I.
Yeah, this big screen they put up here.
Let's see if I can. Mr. Renner, good morning.
Good morning.
Still, yes, okay. I am not up here to beat a dead horse. I think you told us exactly what your intent was on the date, and I appreciate your candor. What I'm going to ask is a little bit more detail about this meeting.
Okay, can I take one at the point of losing my voice?
Oh, actually, do you need
absolutely.
some you have water there?
Yes, I do. Thank you. I apologize. I had this problem.
No
No,
worries.
no problem.
Okay, let's give it a shot.
Okay, I'll try to keep it short. Now, you have, this is not the first time you're telling anyone in about what happened that day, correct?
I told the Attorney General.
Right. They actually came out to interview you, or did you come to see them?
I think so.
Okay.
I think we met on common ground, but in their office.
Neutral territory.
Yeah.
Okay.
I won't say neutral, but it was common ground.
All right. And there was an agent from, Agent Shock was there, correct?
Yes.
And representatives from the Attorney General's office were there, right?
Correct.
And then prior to that discussion that you had, they told you that this interview of you was being recorded.
That's correct.
Okay. And has anyone given you the opportunity to listen to that recording?
Yes, I have.
Okay. And when was the last time you listened to it?
Yesterday.
All right. And so if I can then just forget about the other stuff, let's just focus on the room in the basement, the room in the lower level. There were at some point, people were talking to the entire group, isn't that correct?
Yes.
Okay. And you remember, I think, Ms. Burden may have been talking to the entire group?
Yeah.
Okay. And maybe somebody else, did you say Myra might have?
Myra.
Okay. And I understand it's been a long time since you were there, but there were others in the room besides just the electors, correct?
That's correct.
And those others were sort of behind Ms. Burden and Ms. Rodriguez.
That's correct.
Okay. And I believe that you have said to during your interview that those individuals that were behind them were telling them what to say. Is that right?
There was interaction. I'm not sure if they were directing.
Okay.
But there was interaction, not with all 10 or however many there were, but with some. Okay.
Right.
So I was not privy to the discussions. I did not hear them. So there was interaction. Beyond that, that's all I can tell you.
All right. But do you, and I mean, you said you listened to the recording yesterday. Do you remember telling these individuals that
Yes.
when you were interviewed that those people behind them were telling them what to say?
No, I said it appeared to be.
Okay, I'm sorry. They appeared to be telling them what to
That's
say.
correct.
Okay.
Now, if it was actual, I don't know, because there was a distance, but it appeared to be.
That's how it appeared to you.
Yes.
All right. And when you then, after this discussion to the group, that's when you signed the document.
Yeah.
Okay. And I think you've indicated that you had no intent to defraud anyone when you signed that.
Absolutely.
You had no intent to defraud anyone when you went with the others over to the annex.
Absolutely.
And in regard to your decision to sign this, had it felt like you were doing something wrong, you would have stopped.
Yes, I would.
Got that. 100%, right?
Yes.
All right. And the information that you were being given, you recall who it was that had explained that to you?
I cannot. it was too long ago, no, I cannot. I regret that, but I cannot.
Okay, but you felt that your reliance on what they were saying was reasonable under the circumstances?
Yes, absolutely.
Okay. And you didn't object, right?
Right.
And no, you didn't see anyone else object?
That's right.
And everyone else in the room did the same thing you did?
From what I
By signing.
understand, I did not observe them doing it,
Right.
but it was apparent that the page is full of appropriate signatures. That's all I can say.
Okay. And I'm not sure if this was asked of you earlier. You were aware that there were at least allegations out there in December of 2020 that voter fraud had occurred in Michigan that may have, and that voter fraud may have had an impact on the outcome.
That's correct.
Okay. And I think that you said that you weren't aware of any specific lawsuits that had been filed. Had you read about some lawsuits though?
There was so much going on at that time. To focus on an individual one, the one that I took, not necessarily, but the affidavits from the workers, Republican workers,
Yeah.
at the Detroit County Center, I viewed those as very serious issues that had not been addressed. As far as you mean cases in other states that were challenging or something else.
Yeah. And I'm just talking about Michigan.
Oh, okay.
Yeah.
I didn't really keep up with that. I was more concerning those signed affidavits
Right.
of individuals, and I thought, that's not appropriate. Something's got to be done about it.
Okay. But you wouldn't do anything illegal to try to fix that. To what you saw.
No. Absolutely not.
Just 1 second. I don't have anything further, Judge.
Everyone? Let me redirect.
Briefly. Almost done this one. Now, I believe on one of the cross-examinations, you stated because you had received such short notice, you didn't have an opportunity for research. Do you recall saying that?
Yes, I do.
Before the meeting on December 14th, 2020, did you know how a candidate for elector was selected?
No,
And during 2020, did you attend the virtual Michigan Republican Convention?
no,
Before December 14th, 2020, did you know what, if any, responsibilities a candidate for elector had?
no,
Did you know what triggered a candidate for electors' obligations to vote?
not really. No,
And you said at the meeting on December 14th, 2020, you were listening to appropriate leaders. Could you tell us who you're referring to when you said appropriate leaders?
well, I think it would be Ms. Burden, Ms. Rodriguez. There were other individuals that were active. Sean was active. And there could have been another individual that made a stand-up presentation. But I came away from that meeting for two things. First of all, that process was legitimate. Okay. And second, we were not This was not a marginal or questionable process. That was
I gotta stop because I gotta ask questions.
Oh, I'm sorry. Okay.
No, it's okay. Now,
I'd ask that the witness be allowed to finish his answer.
well, my question was appropriate leaders and he did answer that.
Well, he was still talking, Your Honor.
Okay, well, I think she was stopping him from giving a narrative. So,
Now, because of the short notice.
Yes.
When you received the information from the appropriate leaders, did you have any reason to question it?
No.
And this is based on, you were called in on short notice and you had not done your own research, correct?
That's correct.
So on December 14th, 2020, you did not have any independent knowledge of what the actual process was, correct?
That's correct.
Did you know on your own on December 14th, 2020, whether or not a recount was in progress?
I did not know.
Did you know the process for requesting a recount?
No, I did not.
And did you know on December 14th, 2020, whether or not any pending litigation had been resolved already on its merits?
I was not aware. Again, I wasn't tracking all that.
That's fair. And it was your takeaway from that meeting that the Michigan Senate could take both a Republican slate, a Democratic slate, and choose which one to accept,
That's correct.
but you had done no independent research on your own, is that
That's
correct? And forgive me, councils, I forgot to ask a question on direct. This is actually outside the scope. But I wanted to show Mr. Renner a photo. Permission to approach, Your Honor?
yes.
So, Sheriff, I'm going to hand you what has been marked as People's Proposed Exhibit 32D. Do you recognize that?
Yeah, that was the
So,
picture.
Your Honor, I am going to object. I know it is outside the scope of cross, that I just don't know how many questions about this photo that the government is going to go into, and then we're prohibited from asking any follow-up
You're
on
not
that.
prohibited.
Oh, okay, great. Thank you.
I'm going to keep it short, I promise.
Yeah, that was the picture that was taken near the end of the session prior to us breaking up.
And was this taken on December 14th, 2020?
Yes,
And who is in the photo?
for myself. I can only tell you the people that I recognize. Marion Sheridan. Kathy. Sean. Payne.
Are you able to say that, along with yourself, that you recognize the people that you recognize in that photo as the Republican electoral candidates?
To the best of my ability, I would say yes.
And the people would move to admit People's Proposed 32D.
People's proposed what?
32D.
No objection, Your Honor.
Any objection?
Your Honor.
People's 32D is admitted.
And I have no further questions, and I'll pass the witness on that.
Cross-examination based on what was asked outside the scope.
No additional questions. Thank you.
Can I see the exhibit?
I see it too.
Yes. Mr. Renner, that was, I'm sorry, I'll jump in here. if I could, okay. That photograph was, where was that taken?
I think it was taken in the basement of the second.
Okay.
Yeah.
All right. Just can I add some follow-up on what the Attorney General had asked?
Outside the scope?
No, it was inside the scope. I'm gonna do a little recross, if I could, just a couple questions.
You're gonna recross on her redirect?
Was that where we're at? I've only asked him questions one time. Yeah, on her redirect. If I could.
What do you mean you're only supposed to ask him questions one time? I'm confused.
Okay, good. Yeah, that's fine. I got it.
Okay, any additional cross based on this exhibit?
Can you identify anyone there as Michelle Lundgren?
I could not.
Could you have been able to identify certain people that you named in testimony a moment ago? correct?
Yeah,
How long have you been involved in Republican politics in Michigan?
about 11 years.
Okay. And did you recognize those other persons because you ran into them at various functions in the meetings?
No, I think, first of all, Marion Sheridan, I recognize, because she was the one that got the involvement of the Michael Moore Society, the Moore Society for our civil suit. She's the organizer of that, so I recognize her as a result of that. Kathy and Michelle and Myra, because they were kind of active during the meeting. Okay, those are the Hank, because I talked with him, as a dairy farmer, now as a farm kid.
So as far as you know, the persons that you didn't name, you don't recall ever having seen them before, at least not at a Republican
No,
Party function.
again, I operated primarily at the precinct or the county level. I went to 2 conventions in the past, but not recently, so I'm not that conversant or active with other party members.
Thank you very much.
You're welcome.
I have no additional questions for this witness. Okay, there is, oh, sorry.
So your experience as a police officer,
Yes.
you ever had,
It's only as,
based on the photo, it's about the photo,
oh,
have you ever had a group of criminals pose for a photo at the scene of the crime?
Not that I was privy to.
Thank you.
thank you. Any other questions? Okay, Mr. Renner, there's a sequestration order, so you're not to discuss any portions of your testimony with any other witness, okay?
Yes, ma'am.
Thank you, and this witness may be excused.
Yes, please.
You may be
Thank
excused.
you, Judge.
Okay, it's time for us to take a break. And so we'll take a break for 10 minutes and then we'll proceed with the next witness.
Judge, just for clarity, we're gonna argue the motion of the act, right?
Correct,
Prior to the
Bye, thank you.
yes. Oh, maybe she just stopped again. Back on the record, and we are going to let Mr. Kroger, you have a motion for motion in limine that you want to address.
Yes, Your Honor, thank you. Reason for doing so is we anticipate that Agent Schock's testimony is going to broach what we believe that it is to be very important and significantly exculpatory evidence for the defense. I filed my briefing, received the state's response. So in large part, I will rely on the briefing. It's my understanding the court has received the judge's copy. I think we provided that yesterday by hand. Thank you for bearing with us there. But just some key points that I think I need to reiterate here, Your Honor. It's my understanding that the state is arguing that this evidence is irrelevant to these proceedings. So I'm going to address that first, and then there's 4 distinct purposes and ways this evidence can be considered by the court, but also admitted as an affirmative exhibit. So I'm going to start with relevance, Your Honor. As the court is aware, it's an extremely low bar. Whether evidence is relevant is, really a threshold showing. Court rules and case law support that point. I need to remind everyone, including, I guess, the state, that they in fact charged a criminal conspiracy. And the evidence is going to bear out through Agent Schock, and in part has already been borne out. But when the defense offers its case in chief, it's going to come out that no charged criminal defendant here, it's expected to further be bolstered, individually committed any of the or all of the elements of the charged crime. So viewing the state's case in the light most favorable to it, the evidence will not demonstrate that my client Kathy Burton or any other charged defendant made, signed, and published this document. To the contrary, what is going to bear out is, and the state is well aware of this, these documents were part of a larger plan that originated with a gentleman named Mr. Ken Chesbrough. And his background, he's gonna come and testify. At least that's my understanding. It's going to bear out that he was informed of this alternate elector ability, particularly under federal law that's already been discussed in the court, but by his own personal experience working on behalf of the Gore campaign in 2000. And I referenced in my briefing the ability to mount the alternate elector's position, and the fact that Congress could resolve potential challenges to elections, so on and so forth, was referenced in Justice Stevens's dissent. Well, Ken Chesbrough worked on that case. He had the personal knowledge of 1960 Hawaii. He in fact sat down with an interview with the state and laid it all out, that informed his purpose here. The state in its briefing conceded that I think the quote is, it's well known that this 1960 Hawaii event was the inspiration. They used the inspiration for the alternate elector plan. What's further going to bear out is that once these documents were created with the backdrop of 1960 Hawaii federal law, other historical precedent significant, they were transmitted to the Trump campaign. And when they were transmitted to the Trump campaign, other lawyers took them. There was much back and forth, much discussion about the legality of what they were doing, why they were doing, the intent behind doing it. And all of that information, it's already been, I think Mr. Renner established it. I think Agent Schock is going to confirm this when he testifies. All of that information was kept from the charged defendants in this case, not only Kathy Burton, but everyone. So the reason that this evidence at its base is specifically relevant to criminal intent is it negates completely criminal intent. The people who orchestrated this happening relied on this document, these documents, this historical event, the jurisprudential nature of it in the dissenting opinion. I believe it's cited elsewhere or in other places of former Justice Stevens. So that's what they were relying on. And this, they've already conceded that the bench may take judicial notice of the what the ECA was, the Electoral Account Act was back in 2020. I certainly agree with that. But the point as it relates to this particular document, and we'll get to more specific judicial notice in just a second, but the point is that this document was informed by, created under that that statutory or those statutory provisions. So to explain, this doesn't happen all the time, Your Honor. This is to my knowledge, this specific happening has happened twice in our history. I could be, maybe there was an 1877 event, if I recall, but in recent history, it's been 1960 and 2020. So this document informs the court as to what the ECA is talking about. It gives a good example of it. It's a historical fact. So it's relevant to that, for that point. Again, if the lawyers were relying upon 1960 Hawaii, then they necessarily wouldn't have had the criminal intent in consideration to defraud. I mean, and if they believed that that what they were doing was lawful based on 1961. So it's relevant to completely negate the criminal intent, not just of the charged defendants, but of the conspiracy as a whole. And to the point of the conspiracy as a whole, again, there's not going to be any evidence to support that any individual charged defendant committed forgery, election law forgery, or uttering and publishing. It was a concerted effort, if you view their theory in the light most favorable to them. So they need conspiracy. And just because this is an important, I know, mundane legal point, but just because co-conspirators aren't charged, they still need all of the statements and all of the conduct to form the corpus of the conspiracy. We'll note that I think it was on the first day of our proceedings here, AAG Logan, I think, referred to a Mr. Ian Northman as an unindicted co-conspirator. Well, that's several people. Sean Flynn is the closest person, as I understand it, and I think the evidence is going to bear out. Sean Flynn is the closest person to what the actual intent as orchestrated by the lawyers and the Trump campaign was. There's significant evidence that there's communications between Sean Flynn and I believe a Mr. Boris Epstein, if I remember correctly, Mike Roman, who I understand is not a lawyer, but I guess a PR guy for the Trump campaign. So that's all going to come out. This is all speaking to that. So that's the relevance of it. It negates the criminal intent, just patently negates the criminal intent of the overall conspiracy, which they have to prove. The same goes for any other statements by the co-conspirators, whether it's in text messages where Sean Flynn is orchestrating paperwork 2 hours after the signing, where he's sending it from East Lansing. That's all going to bear out with Agent Shock. So that's relevance. I hope I've hit it hard enough and explained it expressly enough. Now I'm going to move on to the 4 different ways that the court can consider this evidence. Number 1, to resolve the conflict that is clearly here between state and federal law, and why what they are trying, the square peg they're trying to fit into the round hole as it relates to a state crime, to resolve the conflict as to why that does not work. The court can consider all information, all material, so on and so forth. Under, I cited in the brief, MCL 600.2114A, I'll note that the state completely ignored that in their response to our brief. We have provided notice that we are going to raise that legal issue. And under that statutory provision, which is superior to the Michigan rules of evidence and so on and so forth, and expressly states that notwithstanding the Michigan rules of evidence, the court may resolve or consider all information, which includes the prosecutor's memo that's attached to the brief and the AAG's memo that's attached to the brief, and any and everything else related to this very, granted, complicated legal tension that the court, we are going to ask in our briefing to resolve. So that's, as far as I'm considered, an unopposed motion as it relates to 600-2114A, and I believe the court should treat it that way. Number two, the court may consider this specific evidence as it relates to a legislative fact. And the reason that matters here, Your Honor, is under Michigan case law and, well, statute and case law, it's pretty clear that, and I believe Director Brader testified to this, I think AAG Aaron Van Langeveld will testify to this as well. For you to have committed, you being a criminal defendant, a violation of the Michigan election law as it relates to election law forgery, you have to create a document, quote unquote, described in the Michigan election law. The citations to that authority are in the briefing, Your Honor. We have very clearly made it a point to elicit testimony, and evidence suggests very strongly that the state knows that that's the case. This certificate of votes is only described, I believe the National Archivist testified to this yesterday. This document is described in the ECA. I believe it's section 9 of the ECA, 3 USC section 9 as it existed in 2020. So as a legislative fact, this court may take judicial notice of the proffered or the evidence we submitted to inform the court and assist the court in understanding further that this specific document that they charged as a purported forgery is expressly carved out of the Michigan election law forgery body of possible crimes that might be committed. Number three, the court may consider this evidence as an adjudicative fact. I've touched on this. I don't want to spend a lot more time. I'm sorry for taking so much time. It's important to make a record, as the court is aware. So the court can apply this material evidence, and I have to stress the exculpatory nature of this evidence. I would expect that, given the constitutional duties here to permit exculpatory evidence, to provide exculpatory evidence to a criminal defendant, that we shouldn't get a lot of pushback on this. It's purely exculpatory. It's an adjudicative fact to adjudicate the allegations in this case as it relates to criminal intent and the lack thereof of the overall supposed criminal conspiracy. Again, when you view this evidence, it's our position that there is no conceivable way that it will be determined or could be determined that the charged defendants in this case ever had the requisite criminal intent to defraud anyone, and in addition to the uncharged defendants in the overall supposed criminal conspiracy. So that's number three. Number four, it's a little different when, and I will concede this, when we ask to offer it. Judicial notice is a little different when we ask to offer it as an affirmative exhibit. The testimony we expect will bear out that Agent Schock was well aware of these happenings. I believe this was in their, this document was in their discovery, I believe. That I'll let the state speak to that. We received 80,000 documents or something, but I believe it was in there. So as it relates to an affirmative exhibit, the state knew about it. They knew about all this. The Attorney General herself went on public record. That's another thing that can be considered properly under the statutes I cited, and that's taking judicial notice to resolve detention. But she went on record herself saying 1960 Hawaii here doesn't apply. Well, they knew that before they brought these charges, they knew about the 1960 Hawaii problem that they had, yet they still brought charges. So whether it's Agent Schott or whether it's AAG Van Langeveld, the evidence is going to come in that you guys knew about this stuff. Yet nonetheless you charge. Why did you do that? What's your theory, or how do you get this case through? And last point I want to make. So not the last point. Let me back up here. So sorry. So under point 4, yes, it's hearsay, but it's admissible under the exception to hearsay. Hearsay 803 sub 16. It's an ancient document. It's admitted as an affirmative exhibit, and even if it's not, these people I've named can lay a foundation for it, and they can come in that way, or it can be used as impeachment evidence against the state's, I guess, key witnesses. So to the point of the theory of the case, and as the Attorney General herself had said, and it's been said in court here, well, there wasn't a recount, and there was no viable or plausible way that this the results of the election could not have been overturned, or could have been overturned. To that point, Your Honor, I have to stress that they're essentially reversing their burden. They're making us, the defense, at great cost, explain, well, what we did here isn't criminal because, no, it's the other way around. The state has to point to a statute, a criminal statute, common law, some crime that says affirmatively, the only instance you can offer an alternate elector slate is when the candidate has submitted for a recount under state law. There is no such law. Zero. To that point, this evidence speaks directly to not that there wasn't a recount, blah blah blah. We affirmatively can do this under the law. So I have to stress that point. The other thing that's going to bear out, and I think it's important to note now, I know I said one, I like to talk. It's well known in the record, that the considerations of the First Amendment due process protections were expressly mentioned among the lawyers that created this document and these documents. It also cuts to their First Amendment protected right of redress of grievances. Now, we heard testimony yesterday that you get some wacky stuff at the Senate or whatever. No doubt, people say wacky stuff all the time, but it's not a crime. So I also just had to put that before the court. I think it's multiple ways that this comes in. I hope that the relevance objection stops when this is done. Again, this is exculpatory evidence. I think it completely overcomes the state's allegation in this case. And with that, unless the court has any questions, I will leave it there.
Briefly, Your Honor. So first of all, what I'd really like to do today is address the actual request that was made by the defendant's motion. So he asked this court for two things. The first is judicial notice of various components of the ECA. We have absolutely no objection, but as outlined in our brief, we'd like the court to take judicial notice of all of the applicable sections of the ECA. So that portion of the defendant's motion is stipulated to. The second thing the defendant has asked for, and we heard a lot of argument, but what we heard very little of is what is the actual evidence that we're talking about. What is the actual evidence that the defense is asking this court to admit? And what it truly is a
1960 certificate out of the state of Hawaii from the true presidential electors in Hawaii. And those were, as things bore out, the Democrats. So as to that certificate itself, first of all, no court has ever held that what happened in Hawaii is legal precedent for anyone who wants to submit something purporting to be electoral votes for the candidate of their choice. No one has found that that is precedent for that practice. There are a lot of opinions that are out there about that. We certainly can see that many people have opinions about that, but no court has actually held that that is precedent. Hawaii in 1960 during the presidential election was also a very different matter. So the inquiry is not, hey, look at this certificate. It has similar language or even in some places identical language to what the false electors used in this case. That is not the inquiry. In order for that 1960 certificate to be actually relevant, we have to go behind what was truly going on in Hawaii during that time. And what was really happening is that there was a court-ordered recount. The Republican and Democratic electors met together and both cast votes together during the midst of that court-ordered recount because they were all in agreement that that recount could not be completed in time. So this is not precedent for anything, but it is choices that presidential elector candidates made in Hawaii in 1960, but a choice is not precedent. After the recount, it became known that the Democrats had actually won by a mere margin of 115 points. I'm sorry, 115 votes rather. So somehow, Your Honor, this became, and the people do not dispute, that this became inspiration for a multi-state criminal conspiracy that was absolutely linked to the Trump campaign. We certainly agree with that. But inspiration for how to steal an election is not the same as legal precedent. It is absolutely not. So in Michigan, we had, as the court is aware, no court-ordered recount. We know that President Biden won by a very significant margin, approximately 256,000 votes. We also know that by the time the Republican electoral candidates met, that the two major lawsuits challenging the election in Michigan had both been dismissed. And those are the Eastern District case of King versus Whitmer, which was referenced in Mr. Renner's testimony. He briefly mentioned a lawsuit that Ms. Sheridan helped organize, and that would have been King versus Whitmer. In addition to that, Johnson versus Secretary of State, a petition that was pending in the Michigan Supreme Court, challenging the certificates of ascertainment. That petition was also dismissed. And even more than that, before December 14th, when the Republican candidates for elector met, the party leaders within our state, Mike Shirkey and Lee Chatfield, had publicly announced that the legislature was not going to take any action, that they could not take any action because there was no reason to, Your Honor. So that is the situation in Michigan as compared to the situation that we had in 1960 in Hawaii. So taking all of that into consideration and going to what the heart of the people's objection is, which is relevance, it is not possible for the 1960 Hawaii certificate itself, because that's what's being asked of the court, admit the certificate, to negate anyone's criminal intent. First of all, we've had no testimony that any elector was aware of the 1960 certificate, the document that the defense is actually asking to admit. We've had no testimony about that at all, that they relied on it. And it's not possible for, when you take into consideration factually what happened in Hawaii and where we were in Michigan on December 14th, 2020, it's not possible to claim that because the true presidential electors in Hawaii in 1960 met and cast their votes ultimately, that anyone who wants to submit a alternative slate in the absence of any legitimate challenge can do that. So that is our position. It is not relevant. I think that that's in alignment with some of the responses that my co-counsel has given to object objections just to the general line of questioning into what happened in Hawaii in 1960. The court has allowed the defense some leeway regarding that, and I think that the leeway that the court has provided is appropriate, but it does not have to continue on to admitting the 1960 certificate itself. However, if the court views it differently and thinks that the 1960 Hawaii certificate itself will help this court to ascertain something that is relevant in this case, if the court believes that it wants to consider the certificate for purposes of the probable cause determination, what we would ask the court to do is consider that certificate for what it is in the context of what was genuinely going on in Hawaii as compared to what we absolutely did not have in Michigan.
Brief rebuttal, promise on brief. Again, they're making factual distinctions. None of that matters as it relates to the intent. If in fact, and the testimony is going to bear out, that Hawaii was the impetus of this. They reviewed the ECA, they reviewed the historical stuff as it relates to Hawaii, and they came to believe that this was authorized. Doesn't matter what the distinction were. Number one, number two, the margin doesn't matter. Is it one? Who comes up with the margin? Is it one vote? Is it 100 votes? 200? 500,000? Who comes up with that? The bigger question is the principle, the underlying legal principle. Again, they have got to prove that an actual crime was committed, not that something happened that they disagreed with. Oh, it's completely unreasonable that somebody would have maybe thought that the election results could have been overturned. Maybe, maybe, who knows? But the underlying point is the intent of the nationwide criminal conspiracy that was just referenced. If in fact that was to preserve legal rights under the ECA on the date that they had to preserve them, so litigation could ensue, that overcomes intent. And I want to address the cases and everything was dismissed, so on and so forth. That's not true. Just one case that really matters, and this is going to come out one way or the other. There's a case in Wisconsin that alleged significant constitutional problems with the election in Wisconsin, which had national implications that would have been applied had they prevailed. Could have been applied to Michigan, Georgia, Nevada, New Mexico, Wisconsin, and I probably missed Pennsylvania. So just like zoning in on, oh, the Michigan cases weren't live. Well, they were up at the Supreme Court. I think it was Trump v. Biden was denied. They entered the Wisconsin Supreme Court, my recollection serves, entered their order of dismissal on December 11th. They applied for cert in the U.S. Supreme Court on December 29th. In that case, as it stands in my mind, at the U.S. Supreme Court, wasn't denied cert until February 22nd, I believe. So this notion that they can just, get tunnel vision on what might have happened in Michigan courts, it's really not. They're missing the forest for the trees. And the other piece of this is the appellate avenues hadn't been exhausted. Number one. Number two, on that point, most of those cases, if not all that she cited, I believe were dismissed for standing, lack thereof, or laches. No court ever, as far as I know, actually adjudicated the merits of any of those cases. So I don't know. I'll leave that there, Judge. Let me just make sure I'm not missing anything here. She says, the state says there's no evidence that the electors themselves knew about this precedent. Again, they chose to charge criminal conspiracy. So it goes to the entire corpus, everybody that had anything to do with this supposed conspiracy's intent. That's the central issue of the case. And that's what this speaks to. And that's going to be borne out again through Agent Schock, AAG Van Langeveld, and the other witnesses that we intend to call. So, one second, Your Honor, please. So the factual distinction as it relates to Hawaii, and I think this is in the article, I think it's referenced in Justice Stevenson's dissenting opinion, and there's other ways that this will be explained, I think, through some of the witnesses we're going to call, but the state keeps saying the true electors were the Democrats in 1960. Sure, fine. As of, and this is in our briefing, as of December 19th, 1960, they weren't the true electors of that election. In fact, they had been certified by the Republican governor of Hawaii that the Republicans actually won 1960. The reason they voted on December 19th, 1960 was that statutory deadline. I believe it's cited in the brief. There's a statutory deadline that informed that specific date. Again, now, another.
But at the time, there was a pending recount, though, correct? That was already happening.
Yes.
Okay.
Just like there was pending legal litigation throughout the.
No, I didn't ask, was there pending litigation that may potentially lead to a recount? In the Hawaii situation, there was already a recount happening, correct?
I don't know. So I don't know that piece. I think it was being argued in court.
If I may, Your Honor,
No,
it's
let me
cited in
finish.
his
Let
brief.
me, well, if it says it in the brief, there you go.
Okay.
But I will say, the analogous situation is a recount's only one of several ways that a presidential election can be changed. That's our point. So the reason too.
Just what are the other ways?
So there's a recount. Our witness is going to get into this. I think he's probably better equipped to explain it, but I'll just kind of.
So your witness, the defense case will bring out potentially what these other ways would be.
I'll preview it for the court. So recounts one. There's argument, there's scholarly works out there that suggest the ECA in and of itself is unconstitutional, and that it reverts back to the 12th Amendment and the Article 2 of the US Constitution. And we've cited it several times here, 3 USC section 15 at the, and this is cited in the briefing as well, provides that Congress by itself can adjudicate any contests. If members of Congress decide, I don't think Michigan conducted their election sufficiently, pursuant to its own law, they can adjudicate that. My understanding is that happened, I believe, in 1877, where I know it's a long time. This doesn't happen, right? This doesn't happen. I don't envy the position you're in.
1877.
But to that point, it's my understanding, and I think the testimony is going to bear this out, and we can certainly provide additional briefing, that at that time, Congress actually impaneled its own commission to adjudicate the facts internally. And in this particular case, I think it's in the record already. In fact, I know it is with Director Brader. One representative objected to Michigan. It's on video to the Vice President of the United States, Mike Pence, at the time. The reason it wasn't adjudicated in Congress was a senator didn't join her. So, and that's all laid out in section 15. So while a recount's one way, there are multiple ways, like it or not, there are multiple ways that it could be changed. And I'm not saying that we have to take the court, the state, us, a position one way or the other, that somebody had a credible claim of fraud and somebody didn't. I don't think that's the central issue. The central issue in a criminal case, constitutional case like this, is, was it a crime? And I'll end with a reference, void for vagueness. I mean, worst case scenario, this can come in to resolve and inform the bench about what void for vagueness means in this context and how it's applied to this criminal case. I'll stop there, Your Honor. I think I would invite, to the extent, because I think the way the court's doing the record is if you want to adopt something, you can adopt something. So I'd invite the other defense lawyers to chime in.
So I'll adopt the brief filed by Mr. Coker and Mr. Danini on behalf of Mr. Haggard. The only additional thing that I have to say is I quickly pulled up the brief. I don't think that Mr. Coker and Mr. Danini said that a recount was occurring at the time that the Hawaii certificate was signed. There's two places that, or two times recount comes up, and it says she, meaning Dana Nessel, compared Hawaii's 1960 presidential election and the fact a recount had occurred at that time with the fact that in Michigan's 2020 presidential election, no presidential recount occurred. So that the point is, if that's a significant fact in the court's analysis, I don't believe that fact is stated in the brief filed by, again, Mr. Coker and Mr. Giannini. I do think it's relevant whether the court takes judicial notice of the certificate or whether it comes in through witnesses. I think we're going to be hearing a lot about Hawaii in the upcoming hours and whatever day the defense begins its case. But the intent of the various conspirators is extremely relevant. Thank you.
Let's see if any more defense counsel before you make further argument.
Just so the record's clear, I join in the motion.
As does Marianne.
Michelle Lundgren joins in the motion.
So it's like everybody's in. Okay. You
Just
just,
one correction.
did you want to add any that you argument or just,
I'm at actually.
yep, everyone's in. Okay.
I don't fault Ms. Chartier for this because she's looking it up on her computer and it probably is doing keyword searches through the brief itself. What I was referencing is the Western Political Quarterly article that was attached to the defendant's brief, and that is where the court will find that.
Thank you.
Thank you.
Okay. As to the brief itself, I think an exhibit M is the one that attaches the copy of the certificate. That is that question.
Yes, Your Honor.
Okay, that you want to have admitted as an exhibit. Is this under Agent Shock's testimony?
We believe that it can, with Agent Shock, it could be used either as the affirmative exhibit, and assuming he can lay the foundation, I believe he can. And then also it can be used as impeachment evidence should it come up.
Okay, okay, so here we have forgery, conspiracy to commit forgery, and then we have election fraud, election law forgery, which election law forgery is a specific intent crime. So the people do need to, at this stage, put forth sufficient evidence for probable cause standard as to there being a crime, and then that would regard them bringing forth evidence regarding intent. And so this whole Hawaii thing, it's been looming since day one or two. And I did let some of this in early on, primarily because prior to day 1 and 2, I had never heard of this case. So I needed to have a better understanding about what is actually going on here so that I can know how to properly divide this information and to understand as we move in the future as to what potential defense arguments may be. At this point, I think I'm very clear. As to whether or not the court actually needs to see or needs to have a document admitted as to what was filed in the state of Hawaii, because I agree that obviously the circumstances in Hawaii were not on point the same as what was going on in Michigan, but do I think that they were so different that laymen, and I'm meaning the individuals that are being charged here, because these aren't attorneys that are being charged here, would not have reasonably relied on that as the impetus behind what they were doing? No, I think that if that it's reasonable to believe that this could have been information that was used. I think, as Mr. Garrett says, it's part of the larger plan as to why they met or created this document, and maybe the evidence that they're going to present during their case will show that. I'm not sure. I don't know that the court needs the actual document. I think that the information regarding the Hawaii case is beneficial to the court because it does help the court understand the overall intent at the time of the meeting. And that's the major element here. It's the specific intent crime. So to the extent that exhibit will show me that. And I know you don't have the official exhibit. I'll take judicial notice of it.
Thank you, Judge.
Thank you.
And
Thank you,
just,
Your Honor.
just so the record's clear, we've ordered the official exhibits. We expect them certified from the state of Hawaii, and as soon as we get them, we'll provide.
Thank you. Okay, and as to your other request, there was a stipulation, so the court doesn't need to address that. And so we have resolved that motion. We have one more witness today, that's Agent Sharp.
Yes.
Okay, but it is 11:44, so we're gonna take lunch. And I know I rushed everyone's lunch yesterday. I won't do that bad today. Somebody said they wanted QPs and they could be a little slow in there. Everyone needs to be back by 1 o'clock.
Thank you.
Thank you.
Your Honor, is the courtroom locked?
It is
Leave our
locked.
things, okay, great. I made poor Mr. Kraus pack it all up.
Ms. Lundgren, we're gonna take a lunch break and you can be back in an hour, okay?